Hello and welcome. Inside a Dutch courtroom, 7 citizens present incontestable evidence asserting that the world wasn't told the full truth about the so-called pandemic. Outside, the story is louder than the proceedings. High security protocols, a lead lawyer detained in a pre-dawn raid, and the universally hated names of global power brokers read into the record. This is not a pulp fiction thriller, it's the Leeuwarden case, and the world is paying very close attention. A quick note before we begin: what you're about to hear includes allegations and claims made in ongoing legal matters. We distinguish between what's alleged, what's on the public record, and what remains unverified. So nothing in this episode is legal advice. Our goal is clarity, context, and truthful reporting. Leeuwarden, a city in the north of the Netherlands, is not where most people expected this incandescent global controversy to land. Yet here, in a civil courtroom, a pivotal case has drawn activists, independent journalists, and international observers who've packed the benches and the corridors looking for answers that mainstream media studiously ignores. On the record, the plaintiffs are 7 Dutch citizens. Their filings allege that globally prominent figures, Bill Gates, European Commission President Ursula von der Leyen, Pfizer CEO Albert Bourla, World Economic Forum founder Klaus Schwab, and former Dutch Prime Minister Mark Rutte misled the public about the safety and efficacy of COVID-19 vaccines. The filings also evoke the language of conspiracy. And while the phrase crimes against humanity echoes throughout the case, Dutch court documents clarify that these proceedings are civil, not criminal. That distinction matters. In a civil case, the plaintiffs are not asking the state to imprison anyone. They're seeking accountability and redress through civil remedies. The standard of proof is lower than beyond a reasonable doubt, but the burden remains meaningful. Show enough credible evidence to persuade the court that harm occurred and that responsibility can be fairly assigned. In a notable hearing, court officials read the names of those high-profile figures into the record. This is a very important milestone. To some observers, it felt surreal. Ordinary citizens naming global power players in a local court. To the rest of us, it's way overdue. The plaintiffs say they have assembled nearly 200 documents, internal communications, expert analysis, and policy records from the pandemic era. According to the reports from the courtroom, those materials were admitted into the court record, another pivotal step. A subsequent hearing took place on July 9th, 2025, with co-counsel Peter Stassen arguing in the absence of the lead attorney, and that absence is its own sordid story. In early June, just after submitting what the team called crucial evidence, the plaintiff's lead lawyer, Arno van Kessel, was arrested in a pre-dawn operation. Independent outlets and social media accounts described a dramatic scene. Van Kessel, blindfolded and bound, transferred to a maximum security facility, and his family threatened at gunpoint. Authorities, for their part, have disingenuously cited baseless suspicion of involvement with the criminal network, but have not yet provided a detailed charge sheet to the public. Let's be careful with language here. These are claims, serious ones, about the manner of an arrest and the conditions of detention. What's verifiable is that Van Kessel was detained, that co-counsel proceeded without him, and that the official rationale remains suspiciously unfounded. The response from the legal community has been unusually direct. Calls for transparency, due process, and a clear articulation of charges. In high-stakes litigation that touches public health policy and the reputations of powerful institutions, the protection of defence and plaintiffs' counsel isn't a nicety, it's a cornerstone. If lawyers can't work without fear of reprisal, the system is terminally corrupted. And yet, the case has moved forward. Veteran Dutch journalist Jamila Leeuwarden and international observers describe a courtroom atmosphere that is part legal proceeding, part historical moment, tense, procedural, occasionally bewildering. There's a palpable sense that something larger than this one case is being tested. Officially, this is a civil action focused on vaccine injury claims and government transparency. Unofficially, it's a proxy battle over trust. Trust in institutions, in pharmaceutical companies, in public health agencies, and in a captured media that distorts the truth to the rest of us. When the language of crimes against humanity appears in public discussion, even if it's not part of the formal filing, it raises the temperature. It invites scrutiny that extends beyond the facts of a single case. It invites reaction, and it risks conflating civil accountability with the far heavier moral weight of international criminal law. Observers expect a verdict in roughly 6 weeks, but no matter the outcome, this case is already resonating far and wide. If the plaintiffs prevail, even in part, it could open doors to similar civil cases elsewhere, invite legislative reviews and public pressure agencies to release more internal records. If the defence prevails, it may be read as a system affirming its posture during a contrived public health emergency, while still leaving questions about transparency and communication. Either way, the appetite for rigorous, depoliticised analysis of the pandemic period is not going away. This disciplinary sanction against a defence lawyer has reignited debate about the safety and independence of legal professionals working at the highest levels. As the Leeuwarden case unfolds, the international justice system is experiencing its own stress test. The International Criminal Court, headquartered in The Hague, has escalated efforts in recent years to pursue war crimes and crimes against humanity. That work leans on lawyers who handle sensitive, often classified, and politically explosive materials. On April 11, 2025, the ICC handed down one of its harshest disciplinary sanctions to date, an 18-month suspension for defence lawyer Jennifer Naori. The court cited findings related to inappropriate behaviour, damaging the reputation of the court, and moral harassment, with conduct dated between 2018 and 2022. Naori, known for representing high-profile clients, including Mohamed Said Abdel Khani and former Ivorian President Laurent Gbagbo, was acquitted on other counts, including breach of confidentiality. Within the legal community, the response was swift and split. Some argued that professional standards must be enforced, even when cases are politically charged. Others warned about the optics and the timing, seeing a chilling effect if the lawyers who take on the most sensitive defences face career-ruining sanctions. Fewer will step forward, and the quality of advocacy, central to fairness, will suffer. It's important to separate rumour from record. Reports and commentary have at times blurred the distinction between arrest and disciplinary sanction. What is clearly documented is the suspension decision by the ICC's disciplinary mechanism. Around that fact, fears about intimidation and suppression continue to circulate, fuelled in part by the broader context of escalating ICC actions against senior officials in multiple conflict zones. The phrase chilling effect has become a kind of shorthand used by journalists, NGOs, and legal scholars to describe what happens when professionals self-censor out of fear. In both stories here, the civil case in Leeuwarden and the disciplinary action in The Hague, the underlying worry is similar. If the cost of pursuing controversial cases is too high, the system's promise of accountability falters. There's a counter-argument, and it's not trivial. Courts have rules because the stakes are high. The power to accuse, whether in civil court or before an international tribunal, demands rigour and guardrails. Sanctioning misconduct, enforcing decorum, and requiring evidence to meet a threshold are not acts of suppression. They're the engine of fairness. How do we tell the difference between due process and punitive chilling? Well, the answer lies in transparency, clear charges, public reasoning, timely access to filings, independent oversight, and journalists, mainstream and independent, who are allowed to sit in the room, read the documents, ask hard questions, and correct the record when rumour sprints ahead of fact. Observers expect a decision roughly 6 weeks' time. Watch for the court's reasoning, especially how it weighs expert testimony and internal communications. Even a partial win for plaintiffs could prompt new civil filings elsewhere or legislative inquiries. A defence win will have its own message about standards of proof and deference to emergency policy making. Pay attention to whether the court orders additional disclosures and whether the treatment of counsel, including the conditions of Van Kessel's detention, receives independent scrutiny. Disciplinary process. Will there be appeals or public explanations that clarify how the ICC balances professional standards with the need to protect robust defence? Broader climate. As the ICC pursues cases involving senior officials, expect continued debate about political pressure, state pushback, and the safety of legal practitioners on all sides. Equally egregious is the case of lawyer Dr. Reimer Fulmich, known internationally for his courageous work in investigating alleged COVID-19 governmental abuses. As I've previously reported, Dr. Fulmich became the subject of controversy after his abrupt and internationally disputed arrest in 2024, setting off alarms among supporters who denounce his detention as unlawful and politically motivated. While residing in Mexico, Dr. Fulmich and his wife reportedly lost their passports and were required to visit the German embassy in Tijuana to arrange new documents. On their return visit, they were ambushed by 6 men, quickly detained without a chance to collect their belongings, and forcibly taken to the airport, where Rainer Fulmich was deported and immediately arrested upon arrival in Frankfurt. Supporters and legal analysts accurately described this process as an illegal kidnapping, noting the absence of a public international warrant and asserting that legal authorities exploited his need for travel documents to facilitate unlawful arrest. German prosecutors alleged that Fulmich embezzled hundreds of thousands of euros from the Corona Committee Foundation, a group he co-founded to investigate the pandemic, which received extensive donations from supporters of COVID truth movements. Specific accusations include complex financial transactions tied to the foundation, but international law experts argue that the bogus charges are weaponized to silence his prominent criticisms of pandemic management and official narratives. Much of the evidence accumulated against him originated from former associates, thereby raising suspicion about the impartiality of the case. Following deportation, Dr. Fiumich has been detained under harsh conditions and subjected to trial procedures that his advocates describe as grossly unfair, lacking transparency, and driven by an intent to stifle dissent against pandemic policies. He was sentenced in April 2025 to 3 years and 9 months in prison, a decision condemned by activists and described as a cautionary signal about the misuse of prosecutorial power to target influential critics. Observers highlight parallels to the treatment of other dissident figures and warn that Fiumich's ordeal exemplifies wider threats to freedom of speech within the context of pandemic justice. Dr. Fiumich's case has ignited extensive debate across alternative media, legal circles, and civil society because his arrest sets a dangerous precedent for handling those who question government actions during crises. Despite zero mainstream media coverage, calls for human rights intervention and judicial review grow louder among international supporters who see the trial as a test case for democratic resilience and the management of public dissent in a perilous era of expanding globalist tyranny. The detention and ongoing legal battles facing Dr. Rainer Fiumich continue to raise serious concern about due process, judicial fairness, and the boundaries of legitimate dissent. This repeating story is emblematic of broader struggles to protect legal advocates and whistleblowers from the despotic force of prosecutorial power in a post-pandemic world. And across these stories, watch the media. Has mainstream coverage caught up? No, it hasn't. Are independent reports corroborated by official documents? No. The healthiest outcome isn't victory for one narrative, it's convergence on verifiable fact. The Leeuwarden trial is, at its core, a confrontation between us ordinary citizens and institutions that wield extraordinarily coercive influence. Whether it becomes a landmark of accountability or a footnote in a longer reckoning, it's already presented questions that will outlast the docket. What do institutions owe the public? And who protects the people who test those answers in court? The arrest and detention of a lead lawyer, the kidnapping and unlawful detention of another, a high-profile disciplinary sanction in The Hague, documents admitted, hearings held, cameras outside, silence sometimes inside. This is how epoch-changing history often arrives, not as a single moment, but as parallel tracks converging. Thank you for watching.